Chairman, please. Chairman, this has to be withdrawn. This has to be withdrawn.
We won't listen to you.
Chairman, please, we heard what he said. You can't sit here and malign a decision of a court. It's not acceptable. It's not acceptable. Please, don't let us keep doing this, and then set the impression out there we are bad people, we are minority trying to prevent you from. The rules are clear. You've been told the rules severally. Please.
Chairman, I'm sorry. I think that Chairman, we have to help you. With respect, we have to help you. My leader speaks at will. He speaks at will. We all know the practice in this house. Leader, you have to catch the eye of the speaker. You have to respect the chair. This attitude of suddenly punching the microphone and speaking, you are our leader, but you are a member of parliament. You are subject to the same rules as apply to all of us. So, Mr. Chair, I think you should have a word with our leader.
Thank you very much.
Your consent.
Honorable Minority Leader, be guided and candidly land safely. Yes, Honorable Ayarka.
So I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting the rules. Because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So you have to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly and proceed.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court, and it's our right to have a disagreement with the court, most respectfully. Especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree with all due respect with the decision of the court. And when you disagree with the decision of the court, you know what to do.
That's not a problem. But we are making a comment, Chairman. Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana,
you cannot say disagree with the court.
Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court's own ruling and say on this we disagree. What is happening here? Because somebody has super majority? What is happening in this country?
Minority Leader,
What have we done wrong?
I will not have a problem.
I have not attacked any judge. We've not attacked the court.
By way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what it is. That's exactly what it is.
The rules.
I don't have a problem.
Make your preliminary comment as such.
Very well. Chairman, thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected learned Justice of the Supreme Court, who until removed was the Chief Justice, her ladyship Gertrude Araba Isabatoko. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy. A strategy to ensure that these cases languish undefended, creating space for this right competition to proceed. Why?
Now and then, the minority will say that we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. I repeat again, impute improper motives, or impute the integrity of a member or any other person. The Speaker may order that the member withdraw those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution. And he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear. That any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, he has imputed improper motives, and therefore you should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair.
Honorable Minority Leader, please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader, you have the floor.
He's a member.
Mr. Chairman, some of my, yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we have a house governed by rules.
Sure.
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. Still on the response to the point of order being raised. Yes, Honorable.
Yeah, Mr. Chairman, I have been quiet since morning. And I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You be the chairman, Mr. Chairman. I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, let me, please, I have the floor. The majority leader is not about, if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on motions. What motion are we dealing with here? Now, every committee, ever since I became a member of this house, every committee meeting, people, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise the question about what I heard other people say that, well, there had been issues, nobody had the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now we have been here all day. The nominee had not even spoken a word. This objection, that objection, and yet getting nowhere.
You raise a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
Chairman, thank you. Oh, very well. Chairman, nowhere in my submission did I impugn improper motives. Or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that. No, Chair, he was just talking. No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the rank is doing is not right. You were given 5 minutes. We spent 15 minutes. Have the floor. Honorable Dapamako, you don't have the floor. Honorable Roxanne Nelson Dapamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG requested, applied to the court for leave to file out of time. It is a statement of fact that we as the minority are raising as part of our concerns regarding the constitutional overreach. We are not saying anything less apart from what is in the public domain. So, Mr. Chairman, the majority. I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader,
Chairman.
with all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman,
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where you come, force you, speak, put on the mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very loud and clear. If you disagree with it, you know what to do.
Very well.
Proceed.
Don't worry. We are all aware of what this whole thing is leading to, so no problem. Chairman, we the minority hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokulu. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither parliament ally in political projects. It is a guardian of our constitution. the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any questions. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
We have not said that. We have not said that. Listen to him.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give rights to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much.
Thank you very much, Minority Leader. How do you reject a nominee who is yet to be vetted?
Yes. She believes in us.
The report is not ready to be voted for. We are not at the stage of approval. So your conclusion is very preemptive.
Chairman, with respect.
This is not what I want you to respond to.
No, Chairman, but
I don't want your
Chairman, to the extent that you've raised it, I just need to.
Honorable Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected.
We agreed on your position.
We rejected, and we
agreed on your position. Yes. When it is time for voting, then you can vote again. Yes. So we thank you very much, and we wish you a very good luck. Honorable members, Those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. You come and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Please, before I answer the question, may I be expected to, may I be allowed to read a brief, make a brief opening remark?
Yes, you'll be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of June 2008, since 17 years plus. I've been a Supreme Court judge. Before the 11th of June, for 2 years I was a justice of the Court of Appeal. Before then, I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Colombo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81, I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. As a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekende, 1 year in Sekende, and 4 years in Kedetia chambers in Kumasi, where I practiced with my friend, the late Sir John. Until 1988, when I joined the Ghana Prison Service. I I joined the Ghana Prison Service in 1988, and I underwent 6 months military training, and I was posted to Second D. That's where I met my wife. At the time I met my wife, he was also a no rank person. She didn't have any rank, actually. A sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Kanta as a circuit court judge, brought to Kumasi. For 7 years I was circuit court judge, and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years until 22nd of April, when I was nominated to act as the Chief Justice.
3FM 92.7.
In the name of Jesus, let us pray. Father, please walk with us through the bad times as well as the good. May we be heard and understood from the suburbs to the hood. Amen. May you judge us by our hearts and not by our mistakes. And see that we get our breakthrough, however long that it takes. May you fill that void in our souls. We'll lay our fears to rest. But there's no way we can live for Jesus when we're living in the flesh. So I pray that you allow our spirits to be born, grow strong, move on, know right from wrong. 1 John chapter 2, verse 15. Do not love the world or anything in the world. And we know what that means. But listen, we know the distance we need to be away from fire to keep it